All right, well, good afternoon and welcome to the Maryland State Commission on Criminal Sentencing Policies, Sentencing Guidelines, Quick Q&A, and What's New in MAGS 12.1. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the Sentencing Commission. I'm typically the first point of contact for the Commission, so if you've called or emailed with a guidelines related or a MAGS related question, I'm sure we've spoken at some point. And on behalf of the staff, I just want to thank you all for taking time out of your day to attend this training. So with me today is my colleague, Stacy Najeka, our research director, and she's going to be assisting me with answering any questions that you may have throughout the course of the presentation. So let's talk a little bit about the agenda for today's training, because the format is going to be slightly different than what we've done in the past. So we are going to begin this training by reviewing some of the commonly asked questions that are most relevant to this particular practitioner group, that being state's attorneys, parole and probation investigators, and defense attorneys. So these questions are going to cover sentencing guidelines eligibility, specific areas of guidelines calculation, and then the second half of the training is going to be a demonstration in our Maryland Automated Guidelines System, which we commonly refer to as MAGS. So I'm going to focus on a new and important feature that was deployed with MAGS 12.1 next week. Then I'm also just going to walk through a sample scenario of how to properly initiate a multiple criminal event, single sentencing event scenario. Now, even though I have already compiled some questions for us to review, if we get to a topic that may be relevant to a question you have, please feel free to raise your hand. You can unmute yourself, ask your question. Alternatively, you can submit any questions through the chat box and Stacy will respond to you as I kind of continue to go through the presentation. If you do submit a question through the chat box, I do ask that you submit it to the entire group just so everyone can benefit from seeing the question as well as the answer. That said, if you don't feel comfortable doing that, you can send a message directly to Stacy Najeka and she can respond to you directly back. Also coming through the chat box, you should be seeing a PDF of today's presentation that you can download and reference in the future. So let's go ahead and get started here. We're going to begin with a really quick refresher. Now, what is the purpose of sentencing guidelines? The sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are convicted of similar offenses with similar criminal histories, they're treated and sentenced alike. Now, the Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. The guidelines help to achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. Now, the guidelines account for the most common, but certainly not all, characteristics of an offender and their crime, and they're most relevant to the sentencing decision. And they really help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. So to get started, let's look at a common question regarding guidelines eligibility. Now, do Maryland sentencing guidelines apply to misdemeanors? The answer is yes. The sentencing guidelines apply to guidelines eligible misdemeanors and felonies that are prosecuted in a circuit court. So within the last year or so, there seems to have been some confusion. We've gotten a lot more questions about whether the guidelines apply solely to felonies or also include misdemeanors. So again, the sentencing guidelines apply to guidelines eligible misdemeanors and felonies that are prosecuted in a circuit court. So let's take a look at the scope of the sentencing guidelines in greater detail here. Now, the sentencing matters that you see on the left-hand side here, these require a guidelines worksheet. We refer to these as guidelines eligible sentencings. So these include circuit court original sentencings, jury trial prayers and appeals from the district court, but only when a pre-sentence investigation is ordered, and cases adjudicated via probation before judgments. Now, this also includes the new type of PBJ pursuant to Criminal Procedure Article 6-220, subsection C. Now, in addition to original sentencings, we also collect worksheets for reconsiderations, modifications, and 3-judge panel reviews, provided that the sentencing event involves a crime of violence, as defined under Criminal Law Article 14-101, and if there was an adjustment made to the original active sentence as a result of this recent reconsideration, modification, or three-judge panel review. Now, on the right-hand side here, these are sentencing matters that are also handled by judges in a circuit court, but they are excluded from guidelines coverage. So they include jury trial prayers and appeals from the district court with no PSI, if the offense carries no possibility of incarceration, violations of local laws and municipal ordinances, probation violation hearings, criminal non-support and criminal contempt cases, juvenile court adjudications, and then finally, the guidelines do not apply to district court sentencings. So here's another question regarding guidelines eligibility. Now, why can't I locate an offense in the guidelines offense table? There are a couple of answers to this question, but one of the main answers could be that it is not a guidelines eligible offense. So we often get guidelines eligibility questions regarding two offenses in particular, that being a violation of Baltimore City Code 59-2, which is the discharging of a firearm. Now, even though this offense carries the possibility of incarceration, it's a violation of Baltimore City Code. Therefore, it's not guidelines eligible. So if it's being sentenced with other guidelines eligible offenses, it would not be reflected on the guidelines worksheet. Another offense that we get questions about is reckless driving. You often see this adjudicated with other motor vehicle related offenses. But since this particular offense does not carry the possibility of incarceration, it would be excluded from the guidelines worksheet as well. Now, another reason you may have trouble locating an offense in the guidelines offense table is because some of the more infrequent offenses with a maximum penalty of less than 1 year, they may not be in the offense table, though we do make every effort to update it when these offenses are brought to our attention. So if this is the case, it would require a manual calculation of the guidelines for that particular offense. And just want to note that all offenses that carry a maximum penalty of 1 year or less are automatically deemed seriousness category 7 offenses unless otherwise specified by the commission. So if you ever have trouble locating an offense, if you have questions about its eligibility, please always feel free to call us so we can confirm. Now, the Maryland guidelines are scored on two key factors, that being the prior record and the seriousness of the offense. In the Maryland system, an offender score is calculated to account for an offender's prior criminal record. Now, the offender score, it's a summary scale ranging from 0 to 9, and it measures an offender's criminal history accounting for 4 factors, that being the relationship to the criminal justice system at the time of the instant offense, juvenile delinquency record, prior adult criminal record, and then finally, prior adult parole and probation violations. The second component of the sentencing guidelines is the offense seriousness, which is represented in Maryland by the offense score. Now, for property and drug offenses, the offense ranking is based solely on the seriousness of the offense. But for person offenses, so those typically involving victims like assault, robbery, as well as weapon-related offenses, the offense score is calculated by considering 3 additional factors, that being victim injury, which can be physical or psychological. So 1 point is scored for a non-permanent injury, 2 points for a permanent injury or death. Weapon presence, which is the presence of any article or device that reasonably appears capable of causing injury. So 1 point is scored for a weapon other than a firearm, 2 points for a firearm or an explosive. And then finally, special victim vulnerability. So this refers to cases in which the status of the victim tends to render the actions of the offender more serious. So 1 point is scored if the victim's younger than 11 or older than 64, or if the victim has a physical or mental disability. So let's look at some questions concerning the offender score calculation. Here's the most common question we receive regarding the scoring of Part A. And if you've attended trainings in the past, I'm sure you've probably seen this question, but again, this is by far one of the most commonly asked questions that we continue to receive. So, does pretrial supervision constitute criminal justice system involvement for the purposes of scoring Part A? That being the relationship to the criminal justice system when the instant offense occurred. The answer, generally no. So let's take a look at why that is. Now, the offender should receive 1 point if they are in the criminal justice system. So, for example, if they are currently on parole, probation, etc., as a result of an adjudication of guilt at the time the offense was committed. Now, criminal justice system involvement, it must be as a result of an adjudication of guilt. And that's why generally pretrial supervision or the defendant being out on bail would not count. Now, let's say someone was on pretrial supervision. Maybe they were adjudicated of the particular offense and were still on pretrial supervision pending sentencing. If the instant offense occurred after the adjudication of guilt and prior to sentencing, then that would constitute criminal justice system involvement. But again, generally pretrial supervision would not constitute a point for Part A. Now here's another question pertaining to the scoring of Part A of the offender score. Does the sex offender registry constitute criminal justice system involvement for the purposes of scoring Part A? And the answer is no. So at the Commission's September 17th, 2019 business meeting, this topic was discussed, and there was a majority vote against including sex offender registration in Part A's definition of criminal justice supervision involvement. So therefore, if the defendant was on the sex offender registry as a result of an adjudication of guilt at the time the instant offense occurred, as long as there was no other form of supervision taking place, meaning they were off any type of probation, parole supervision, 1 point would not be scored for the defendant being on the sex offender registry. All right, so moving on to prior adult criminal record, and we're going to spend some time kind of breaking this down because it's probably by far the most complicated component of the offender score. So aside from a few exceptions that we're going to review in a moment, the prior adult criminal record generally includes all adjudications preceding the current sentencing event, whether the offense or offenses were committed before, during, or after the instant offense or offenses. Now, here's an important question and answer to keep in mind regarding the scoring of the prior adult criminal record. Should adjudications that were expunged from the record or proven by the defense to have been eligible for expungement as a matter of right prior to the date of the offense be excluded from the prior record score? So the answer is yes. Any adjudications that were expunged or proven by the defense to have been eligible for expungement prior to the date of the instant offense should be excluded from the prior record score. So a common instance of a prior adjudication being eligible for expungement, it may involve a prior probation before judgment. Perhaps 3 years had passed since the defendant successfully completed their probation, and therefore it would generally be eligible for expungement. However, I do want to note that expungement laws, they have expanded over the years, and certain prior convictions are now eligible for expungement after a specific period of time. So not solely limited to probation before judgments. So just a further note, Subtitle 1 of Title 10 of the Criminal Procedure Article outlines the expungement criteria for various offenses. So just something to keep in mind. Now, as a reminder, the prior adult criminal record shall also exclude violations of public local laws, municipal ordinances, contempt and criminal non-support offenses, adjudications based on acts that are no longer crimes, non-incarcerable traffic offenses, and then finally, military adjudications imposed by an Article 15 proceeding or summary court-martial, and findings of guilt by a general or special courts-martial if the elements of the offense require the defendant's service in a military force, or do not constitute an offense under Maryland law. So again, keep these in mind. These should be excluded from the prior adult criminal record. Now, here's another common question we receive about scoring the prior adult criminal record. How many adjudications per criminal transaction should be counted towards the prior record score? The answer is 1 adjudication per criminal transaction. So let's break down the steps in calculating the prior adult criminal record, just as a bit of a refresher here. Now, the first step is to identify the offense with the highest seriousness category for each prior criminal transaction. So if you have multiple adjudications that are stemming from the same criminal transaction, You're only going to count the offense that has the highest seriousness category among them. Step 2 is then to count the number of offenses in each seriousness category, using only the offenses that you identified in Step 1. Step 3 is then to refer to our criminal record matrix to identify the corresponding prior record level. We're going to walk through a hypothetical prior record in a second here to tie this all together. But before I do that, I do want to note that Maryland also allows for what we refer to as the criminal record decay factor, meaning if the defendant has remained free of criminal justice system involvement, so they have been off parole, probation, mandatory supervision, etc., for 10 years prior to the instant offense, the criminal record should be reduced by 1 level, meaning if you initially score it to be a moderate record level, but it meets this criminal record decay factor criteria, it would then be reduced from a moderate to a minor record level. So here's a screenshot of the prior adult criminal record matrix that is used to determine the level of the defendant's prior criminal record. Let's walk through an example of how to utilize this matrix. So let's say a defendant has a hypothetical prior record of the following. Let's say back in October of 2015, the defendant was adjudicated of second-degree assault as well as a wear, carry, transport of a handgun. Now, the assault second degree is a category 5, where carry transport of a handgun is a category 7. Since both of these adjudications are stemming from the same transaction, I'm only counting the more serious offense, that being the second degree assault, towards the prior adult criminal record score. Then let's say in July of 2018, the defendant was convicted of second degree burglary, which is a category 4. And then a couple years later, in December of 2022, was convicted of destruction of property less than 1,000, which is a seriousness category 7. Now, among these 3 adjudications that you're counting towards the prior record, it's the second degree burglary that has the highest seriousness category, that being 4. So when I'm looking to the matrix here, I'm going to look to my seriousness category column on the left-hand side, and then looking to the number of adjudications within that seriousness category. So I have 1 seriousness category 4 adjudication, which means I'm going to be looking to this first column here. So seriousness category 4, 1 adjudication, I'm going to bring up this first box here. So I can see that initially this defendant's prior record would result in a moderate record level, and then would jump to a major if combined with 2 or more offenses in categories 4 through 6, or any other 6 offenses. So I only have 1 other offense that falls within these categories 4 through 6, that being the assault second degree. So this doesn't bump the defendant up to a major record. It would remain a moderate record. So hopefully that was helpful to kind of tie that all together. Again, I know that it can be complicated, so if you ever have questions about scoring the prior record, please always feel free to reach out to us. Now, here's another good question pertaining to the scoring of the prior adult criminal record. If a seriousness category changes for an offense, which seriousness category do I use to calculate the prior adult criminal record? And the offense seriousness categories in effect at the time of sentencing shall be used to calculate the prior adult criminal record. So let's walk through one more example involving some offenses where seriousness categories have changed. So here, let's say we have a hypothetical record. Back in December of 2017, the defendant was convicted of possession of cocaine, which is a seriousness category 7. Then in October of 2019, the defendant was convicted of possession with intent to distribute cannabis. Now, possession with intent to distribute cannabis, it is now a seriousness category 5. It was reduced from a 4 to a 5 due to the decreased penalty that went into effect on April 1 of 2023. So I'm going to be using this new seriousness category 5 when scoring the prior record. And then finally, in January of 2022, let's say the defendant was convicted of possession of cannabis. I was able to identify that it was 2.5 ounces or less. Now, the possession of cannabis, it would not count towards the prior record, since 2.5 ounces or less has now been decriminalized. So you would then just be applying the PWID of cannabis, which is a 5, and the possession of cocaine, which is the 7. So again, I have 1 seriousness category 5, which is the most serious here. I'm looking to my seriousness category 5, 1 adjudication. So the first box here, I can see Initially a minor, bumps up to a moderate if combined with not less than 3, nor more than 7 offenses, and then would be a major if combined with any 8 offenses. So doesn't meet the moderate or major criteria, meaning this would result in a minor record level. So again, just something to keep in mind. All right, so let's move on and review some questions pertaining to the calculation of the offense score. So here's a question pertaining to the scoring of victim injury. Should non-permanent or permanent victim injury points be scored for offenses involving photographic or video evidence of child pornography? And the answer is that permanent victim injury points should be scored for these offenses. So this instruction can be found in our guidelines manual and is intended to apply permanent victim injury points to any offense involving photographic or video evidence of child pornography. So it is not limited to convictions for the possession, manufacture, or distribution of child pornography. It could also apply to offenses if evidence of child pornography is present, such as sexual solicitation of a minor, visual or camera surveillance of a private place, human trafficking, etc. So the scoring of these permanent victim injury points, it recognizes that photographic and video evidence of child pornography often exists in perpetuity, and the victims of these crimes suffer lasting psychological consequences and are re-victimized every time an image is viewed, possessed, or distributed. So this was a question and answer that I wanted to review. These instructions went into effect a couple of years ago, but with some conversations I have with state's attorneys and parole and probation investigators, sometimes I'm reviewing guidelines calculation with them involving child pornography cases. And when we're kind of reviewing the offense score, I'll notice that victim injury does not have permanent victim injury points scored. And so a lot of people may not be aware that these instructions went into effect a couple of years ago, which is why I wanted to highlight this during a training. So just keep in mind, if you're calculating guidelines for these types of cases, permanent victim injury points should be scored. All right, moving on to a question related to weapon presence. Now, how many weapon presence points are applied when a weapon is feigned? The answer is 1 point, which equivalates to a weapon other than a firearm. So this rule went into effect on February 1 of 2024, and the revisions addressed an inconsistency that was brought to the Commission's attention by an assistant state's attorney. Now, the Maryland Sentencing Guidelines Manual and COMAR, they define weapon presence as the presence of any article or device which reasonably appears capable of causing injury. Now, prior to February 1, 2024, the instructions stated that the score should be 0 if a weapon was feigned but no weapon was actually present. Now, taken together, these instructions were confusing. Although feigned weapons are not real weapons, they can still appear reasonably capable of causing injury. So to eliminate that above consistency, the Guidelines Manual and COMAR now provide the following instructions concerning feigned weapons. So if a weapon was feigned but no weapon was actually present, the score shall be 1, a weapon other than a firearm. Now, a feigned weapon shall be scored 1 point when an individual intentionally creates the false impression that there is an actual weapon present. So examples can include a finger used to simulate a gun, a written note stating that there is a dangerous weapon present, or a verbal statement that there is a dangerous weapon present. All right, now here's a common question we receive pertaining to the overall calculation of the guidelines. Now, if the indictment includes multiple offenses that were committed over a period of time, should they be treated as one criminal event or multiple criminal events? Now, we get this question for a lot of cases involving child sex abuse, sex offenses that may have occurred over a period of time, as well as theft-related cases, theft schemes that occurred over a period of time. And the answer is that I can't really give a definitive answer. It really depends on the circumstances of the case or cases. Now let's review what constitutes a single criminal event versus a multiple criminal event for guidelines calculation purposes. So we define a single criminal event as one or more crimes committed in the course of the same transaction. Now, in determining whether multiple crimes are committed in the course of the same transaction, the person filling out the guidelines worksheet shall consider whether the crimes were 1, committed close in time in an uninterrupted course of conduct, 2, occur in the same location, and 3, are similar in nature or intertwined. So, for example, whether they share a common scheme or purpose. Whereas multiple criminal events means more than one criminal transaction was committed over a period of time. Multiple criminal events being sentenced together, they may have occurred on the same date or different dates. But generally, offenses that occur on different dates are almost always going to be considered separate criminal events. So ultimately, it is at the worksheet preparer's discretion as to whether you're treating those types of cases as one ongoing criminal event or multiple distinct criminal events. Now, if the defense happened to agree, then ultimately that can be brought to the judge's attention at sentencing, and the judge would make the ultimate decision. But hopefully these definitions help to provide some guidance in determining the number of criminal events. Now, here's another question related to the overall calculation of the guidelines. Is the multiple victim stacking rule limited to person offenses? The answer is no. So the stacking rule is not limited to person offenses. It can certainly be applied to property offenses as well. So for example, if you have a theft case, theft scheme, that involved separate distinct victims, you could certainly utilize the stacking rule in that instance as well. So let's quickly recap the criteria for applying the multiple victim stacking rule. So there must be a criminal event with multiple distinct victims. There cannot be more than one seriousness category 1 or 2 offense, and only one adjudicated offense per distinct victim may be used to calculate the guidelines. So if you have multiple offenses that relate to the same victim, you're going to be applying the stacking rule to the offense with the highest upper limit. And then finally, it's only the upper limits of the guidelines that stack when utilizing the stacking rule. So that concludes the first part of the presentation where we reviewed some of the more commonly asked questions. Before I jump into the MAGS demonstration, I want to give you all an opportunity to ask any questions relating to those topics we just went over, or any general questions. Does anyone have a question that they want to ask before we move into the MAGS demonstration? I'm just going to quickly scroll. I don't see any hand. You can feel free to raise your hand, unmute yourself. Okay, I'm not seeing anything. We'll still have some time at the end if you think of a question. So bear with me 1 second here while I go ahead and pull up MAGS. Okay, so you should now be seeing the MAGS login screen here. So just give me 1 second. I'm gonna go ahead and quickly log in, and then we'll talk about some MAGS features here. Okay, so after logging in, you're going to be brought to the MAGS home screen. Obviously, it's from this home screen that you can create a new worksheet, or you can view, edit, or delete an existing one. Now, one feature that I want to quickly point out to you all, it was deployed last July with our MAGS 12.0 deployment. It's this reconsideration, modification, or 3-judge review for COV sentences feature. Based on some conversations I've had with state's attorneys over the last year, well, less than a year, but over the last couple of months, some of you are not aware that this feature exists. So I want to quickly point it out, show you how it works, because it's going to save you a lot of work moving forward. So earlier in the presentation, we talked about, in addition to original sentencings, how we also collect worksheets for upcoming reconsiderations, modifications, and 3-judge panel reviews, as long as they involve a crime of violence and there is an adjustment made to the original active sentence as a result of that recent reconsideration, modification, or review. Now, prior to MAGS 12.0, you all were initiating worksheets from scratch for that upcoming reconsideration, modification, or review. Now, by guidelines rule, the guidelines should be the same for the reconsideration, modification, or review as they were for the original sentencing event. So you all were essentially copying how the guidelines were calculated for the original sentencing event. Now, this feature is going to streamline that whole worksheet initiation process for you all and basically allow you to copy how the guidelines were calculated for the original sentencing event. Now, the only caveat is that the worksheet for the original sentencing event has to have been submitted through MAGS in order for this feature to work. But let me walk through the steps and show you how it does work, assuming the original worksheet was submitted here. So let's say I want to initiate a worksheet for an upcoming reconsideration, modification, review. I'm going to check this little box. Once I do that, you see the majority of the search fields are grayed out and disabled, meaning I can only search by the case number. So I'm going to go ahead and plug in my case number here and then click search. So you can see once I do that, I get a return for a John Smith. With that case number, I can see it was sentenced back in 2023. If I look to the submitted column, it has a little check mark here that confirms that it was in fact submitted. And then on the left-hand side has the word submitted. And then I see this little copy feature next to it. Now you would simply click copy. It's going to ask you to confirm that you want to copy it. You click OK. And then you're going to be brought to the offender information tab here. Now, again, the majority of these first few tabs here, they are going to pre-populate based on the information that was submitted on the original worksheet. The majority of the fields are also going to be grayed out, so you cannot make edits to them. That said, there are a couple of fields that are editable. For example, PSI status, representation, because it's possible that those things have changed since the original sentencing. But really, you would just be proceeding with entering the worksheet preparer name, title or agency, and then assuming all of that is completed, you just click Save this page. That's pretty much all you have to do. If I quickly scroll through and click on offender score, I can see that pre-populates based on what was originally submitted, as well as the offense here. The last field that we ask that you do submit partially or complete rather partially prior to the reconsideration would be victim information, which is the same as you complete for any worksheet here. And then post-sentencing, judges and their designees would be going in and entering the modified sentence information. So that's how that feature works. Again, wanted to point it out. It would save you a lot of work moving forward. So please utilize that feature when appropriate. Now, one other field that I want to talk about before we get into this new feature that was deployed with MAGS 12.1 last week is the worksheet ID field. So I'm going to quickly search for a test case here. Let's just say I'm generally searching for a Thomas Adams. Now you can see once I get my search result, I can see Thomas Adams, and it has two unique case numbers, one ending in 1144, the second one ending in 1157. Now I want to talk about the worksheet ID field. When you have multiple criminal events that are being sentenced in front of the same judge on the same day, they constitute one sentencing event, meaning that one set of sentencing guidelines should be initiated for that sentencing event. So even though you would have multiple unique case numbers, you're still only clicking this Add New button one time to initiate the worksheet. And then when you get to the List of Offenses tab, that's where you can add all of that unique case number information. We're going to walk through how to properly initiate a multiple criminal event, single sentencing event scenario in a moment. But I want to note that if you're searching the system or if you just want to confirm that you did initiate a multiple criminal event, single sentencing event scenario correctly, you want to look to this worksheet ID field because those multiple criminal events, often identified with multiple unique case numbers, they should share or be linked by the same worksheet ID. And that is how you know that a multiple criminal event, single sentencing event scenario was initiated properly. Now, let's say even though these two cases were being sentenced together. Let's say you clicked this Add New button 2 different times to create 2 separate worksheets, one for each case number here. So if I were to just generally search for a Thomas Adams, I would see them correspond to 2 different worksheet ID numbers. Now, there are 2 issues that occur when that happens. The first and biggest issue is that the judge is not presented with a proper overall guidelines range. The second comes into play when judges in their designees go to officially submit the worksheets. What happens is they're able to submit the first worksheet no problem. When they go to submit the second worksheet, they get a duplicate error message. And it says there's already been a worksheet submitted that contains the same SID number, date of birth, and date of sentence. And that's MAGS's way of catching these multiple criminal events, single sentencing event scenarios. So then they reach out to us, we have to combine the worksheets for them and send them back a revised PDF. So I do want to point out that we have implemented a new feature with MAGS 12.0 last week to help get ahead of that problem and prompt you all to properly initiate multiple criminal events, single sentencing event scenarios properly. So let's walk through how that feature works. The last thing I want to note kind of when searching the system in general, you always want to get in the habit of searching to make sure that you're not creating a duplicate worksheet. So this is especially true with state's attorneys and parole and probation investigators. Sometimes state's attorneys may go ahead and um, initiate the guidelines worksheet not knowing that a pre-sentence investigation was going to be ordered. So then parole and probation comes in, they search the system and already see a worksheet created. So if that happens, we would ask parole and probation to review the worksheet already initiated. If you don't agree with the guidelines calculation, we ask you to reach out to the state's attorney, have a conversation in hopes of coming to a consensus regarding the proper scoring of the guidelines. We're really trying to avoid duplicate worksheets in the system. If there were duplicate worksheets, it gets very confusing for judges and their designees to know which worksheet to ultimately submit. So again, just a good habit to get into, searching the system to avoid duplicate worksheets. One thing I also forgot to note right before I jumped into this MAGS training, for any defense attorneys that are attending this training, even though I'm logged into MAGS right now, I do want to note that our guidelines calculator tool, which can be accessed from our website, it's a standalone tool and it can be utilized by anyone to calculate sample guidelines. You don't need a user ID or password, and it essentially mirrors MAGS. So these first couple of features that I'm pointing out aren't going to be relevant to the guidelines calculator tool because the tool itself doesn't save any data. But once I get into creating a multiple criminal events, single sentencing event scenario, all of the steps I'm going to be walking through apply to the guidelines calculator tool. So I just want to encourage you all to stick around so you can see how a multiple criminal event, single sentencing event scenario should be properly initiated. Okay, so let's get into this new feature deployed with MAGS 12.1. So keeping in mind this Thomas Adams case, right? Let's say we already have these two case numbers, 1144, 1157, that have been properly initiated under one worksheet ID. So let's say I'm going and I'm adding another worksheet for Thomas Adams. Maybe I'm not knowing that the worksheets for these other two cases were already in the system. I forgot to search. So I'm kind of initiating a new worksheet for this defendant from scratch. So I'm just going to begin by entering my general information here for the worksheet preparer, as well as for Thomas Adams. So PSI status, jurisdiction, we're going to do Anne Arundel, public defender, and then race here. Okay, so once I go ahead and click save, you can see I get this duplicate worksheet message. Now, since it's a new feature, I know there's a lot of text, but bear with me while I read through this. So this message says, the offender's name, date of birth, and jurisdiction are the same as another existing worksheet ID. If there are multiple cases being sentenced as part of the same sentencing event, that being on the same day in front of the same judge, the worksheets for all cases need to be initiated under one worksheet ID to ensure proper calculation of the guidelines. If you are attempting to enter information for a case that is being sentenced on the same day and in front of the same judge as one of the existing cases below, please click Select next to the case information of the already existing worksheet and then add this instant case information. So before we move forward with clicking select, I do want to note that it further says if you're initiating a new guidelines worksheet for a case that is being sentenced separately from the cases listed above, click continue with initiating new worksheet for new sentencing event to continue with this worksheet. So if you know for a fact this worksheet you're initiating is not being sentenced with these other case numbers, you can simply click continue with initiating new worksheet and go on like you normally do. Now, if you get this message and you say, oh, wait a second, this case that I'm initiating guidelines for is being sentenced with these other case numbers. In this particular scenario, it's a little bit easy because these other two case numbers, they are already properly linked to the same worksheet ID. So you could really click select next to either one of them, and it's going to bring you, and then you would proceed with going to the list of offenses tab. I'm going to show you what that looks like in a second here. But I do want to point out, if you get this duplicate worksheet alert message and it contains a couple of different case numbers that have different worksheet IDs, if you know that those multiple unique case numbers are actually a part of the same sentencing event, this alert only lets you select one, because the ultimate goal is to combine all of that unique case number under one worksheet ID. So you'd be clicking select next to one of the cases that corresponds to one worksheet ID number, and then it would still be your responsibility to make sure that you're adding that other case information from that other worksheet ID number. Again, to make sure all case numbers that are being sentenced as part of one sentencing event are combined under one worksheet ID. Okay, so let's go ahead. I'm going to go ahead and click select. Now I get a little alert. It's telling me you're now editing that worksheet ID I just clicked on. Proceed to the list of offenses screen to add additional case information. So generally, if you're clicking select next to one of those case numbers, offender information, offender score, and probably the list of offenses has already been completed for those other cases. So you can generally just go right to the list of offenses tab. Here, once I do that, I can see these other two case numbers appearing that I just saw. I can see that they're being treated as two separate criminal events, which makes sense because generally offenses that occur on different dates, they might have different case numbers. So I'm treating those as separate criminal events. So then you would really just click add offense, which brings you to the offense offender score screen. And let's assume that the case I was initially initiating guidelines for, again, has a separate unique case number, separate offense date. So I want to consider this criminal event number 3 of this sentencing event now. And let's say it's count number 2. So I'm going to say this has a completely separate offense date, and it's going to have its own case number. And then just quickly go through, let's say this is a burglary first degree. That's a property offense. I'm just going to click part A of the offender score, calculate guidelines range, save this page, and close out. So here, now I have 3 separate case numbers, 3 separate criminal events, but properly initiated under one worksheet ID. So that's the new feature that was deployed with MAGS 12.1. We're happy about it. We're excited about it, again, because it will really prompt you all to properly initiate these types of scenarios, leading to the judge being presented with a proper overall guidelines range. Now, before I move on to quickly going through a multiple criminal event, single sentencing event scenario from scratch, does anyone have any questions about any of the features I just quickly went through? Scrolling, no. Okay. Okay, so I'm going to continue on. Again, we can always circle back towards the end here. So let me go back to the home screen. Let's say I search the system for, again, the set of guidelines I want to initiate. I don't see anything initiated for this particular defendant. So I'm going to start completely from scratch. I'm going to click Add New and click OK. So again, we're very familiar with the offender information tab at this point, but let's start from scratch one more time. Going to quickly go through here, and this is going to be an Edward Smith. So let's say 7/15, 2000, a PSI. Let's just choose Kent County here, maybe private attorney. Do these two. Okay, save this page, and then jumping to the offender score. Now, I'm sure many of you are probably familiar with MAGS, so I'm not going to break down every single field that we're trying to capture here, but we know Part A is scored on the offense offender score screen because that's scored at the offense level. So then you're just proceeding with making juvenile delinquency, prior adult criminal records. I do just want to point out, if you are applying the criminal record decay factor, You would initially select whatever the adult criminal record resulted in, and then if you click yes under apply criminal decay factor, that does jump it down a level. And then when you view the worksheet, it's clear on the worksheet that the decay factor was utilized. So you want to make sure that you're flagging the decay factor properly. And then finally, let's do prior adult parole and probation violations as yes. So let's save this page. And then we're moving on to list of offenses. Okay, so we begin quickly by clicking add offense. We're familiar with the offense offender score screen by now. So I'm going to begin by entering event number 1. And again, you want to make sure when you have a multiple criminal event, single sentencing event scenario, that you are properly noting the criminal event number. That's how MAGS knows how to calculate that overall guidelines. All right, so let's do count number 2. Let's say this offense date is 205. All right, most common offenses button. So in this scenario here, I'm going to do 2 assault first degrees, each of which involve a separate victim. So I'm going to utilize the multiple victim stacking rule here. Now, if you have an offense involving an attempt, conspiracy, or solicitation, you would simply select the appropriate radio button after selecting the underlying offense. Any enhancement that you would be applying here, such as subsequent drug offense, if they're being convicted as a subsequent crime of violence or a repeat sex offender, you would apply those here. Now, as I just mentioned, I am going to utilize the multiple victim stacking rule. So I'm going to click yes. You get a little alert reminding you when you can utilize this rule. Just click OK. Now, a new feature that was deployed last year is that you will now identify the victim number associated with the offense whenever you're utilizing this flag. So this is going to be for victim number 1. And then jumping down here. So I mentioned part A scored at the offense level. Just go ahead and score 0 here. Jumping over to the right-hand side, the offense score is going to be enabled whenever you select a person offense. So you would then just proceed with entering scores for victim injury, weapon presence, or special victim vulnerability. And then you click calculate guidelines range. So I'm clicking save this page and close. So there I have my first offense. And again, I'm going to quickly go through adding that second assault first degree to the same criminal event as what I just entered here. So this is going to be criminal event number 1. Let's say this is count 5. Oh, what did I enter for that? Let's just assume I entered 3/15/2015 for the last one. And then the same case number here. And then jumping to offense title. Again, I'm going to select the assault first degree, jumping over and flagging it for the stacking rule. Victim number 1 cannot be utilized because I've already used it, so I'm moving on to victim 2. And then jumping down, 0 points for relationship. Again, injury non-permanent, weapon other than a firearm, no special victim vulnerability. And save this page and close. Okay, so there I have my 2 assault first degrees. Stacking rule was correctly utilized because I can see the upper limits for each of those offenses were stacked, giving me so far an overall guidelines range of 5 years to 20 years. Okay, now jumping in, I'm going to add a second criminal event. So this is going to be criminal event number 2. Say it's count 1 here. So let's just say this occurred like 2 weeks later on 4/1/2025. So this is going to have a different case number. And I'm going to go ahead and search for a distribution of heroin. So a couple things I want to point out about searching for an offense here. There's a couple of different ways you can search: by offense title, CGIS code, source code, or type. Or you can simultaneously search all of those columns by utilizing this general search feature here. So one thing I want to note, going back to a commonly asked question that we reviewed earlier, if you have trouble locating a particular offense in the guidelines offense table, but let's say it carries a possibility of more than 1 year of incarceration, you're pretty certain it should be in the offense table, but you're having trouble locating it. It could be because you're searching very specifically, especially when it comes to the statute. So I will note that generally our offense table contains the penalty portion of a statute. So if you're searching for like the offense description, which is typically like a first part of a statute instead of the penalty portion, that could be a reason why you're having trouble locating it. So all that to say, it's better to more generally search for a particular offense. For example, if I was trying to find this 5-601, you can see we have various subsections here. So if you just want to make sure you're locating the proper one, you can just try searching generally by 5-601. Same up here if you're just searching by the offense. Sometimes it's better just to enter one keyword. So for example, if I'm looking for distribution of heroin, I just simply typed in heroin, and then I get all of the offenses that contain that word heroin. So here I can kind of quickly select the distribution of heroin that I'm looking for. This is a drug offense, so I just have to jump down, click Part A, click Calculate Guidelines Range, save this page, and close. Okay, I'm going to add one more offense to criminal event number 2. So let's say this is count 4. It's going to have the same offense date as what I just entered. And I'm going to search generally here. So this offense I'm looking for is this knowingly violated criminal law article 5-602 with a mixture of heroin and fentanyl. So I'm going to go ahead and click select here. Again, it's a drug offense. I just have to go and select Part A and then click calculate guidelines range. Now you can see once I do that, I get this additional dropdown that says mandatory consecutive offense. I'm going to click on this little information icon. You see them scattered throughout MAGS. If you ever have a question about what we're trying to capture in a particular field, I would definitely encourage you to utilize those icons. So the mandatory consecutive requirement. So this is saying to obtain the upper limit of the overall guidelines range for a criminal event with multiple offenses, and the sentence for one of the offenses is statutorily required to run consecutive to the sentence for another offense in the same criminal event, the person completing the sentencing guidelines shall add the upper limits of the guidelines ranges for the 2 eligible offenses whose sentences are required to run consecutive to one another. I know that's a mouthful. So in short, statutorily, the sentence for this knowingly violating criminal law article 5-602 offense, statutorily, the sentence needs to run consecutive to another offense within the same criminal event. There's about 10 offenses that we identified that meet this criteria. So if you ever select them in our offense table, you're going to be prompted to essentially link it to another eligible offense within the same criminal event in order to stack the upper limits for those 2 eligible offenses. So here, since I added the knowingly violating, if I click on this dropdown under mandatory consecutive offense, I can see the only eligible offense in that criminal event is the distribution of heroin. So I would click that and then jump down to calculate guidelines range. And then those upper limits for the 2 offenses are going to be stacked to reflect the mandatory consecutive nature of the sentence for the knowingly violated. Now, let's just say maybe you got that drop down, weren't really paying attention to it, so you just saved this page without linking it. Do want to note that MAGS gives you yet another little alert saying to please address all offenses that have warnings. So if you ever see this little triangle next to an offense on the list of offenses tab, it's indicating that the sentence for that offense is a mandatory consecutive sentence. So you just want to click on this little alert, click OK, and then again, it's going to bring you back to this dropdown and prompt you to link it to the other eligible offense in that sentencing event. So then I'm clicking save this page and close. And now I'm good to go. So now I have my 2 criminal events with an overall guidelines range of 5.25 years to 25 years. And then really the last tab that should be partially completed prior to sentencing is victim information. Again, you can utilize these icons to get more information as to what we're trying to capture there. That said, not all of these fields can be completed pre-sentencing. For example, whether the victim was present at sentencing, if they gave a written or oral victim impact statement. So those are completed by judges and their designees post-sentencing. Okay, so now I have my completed worksheet that should be initiated prior to sentencing. To view worksheet, you just click that View Worksheet PDF button. which brings you to our PDF here. Now, the last thing that I want to point out when it comes to reviewing the PDF is that by guidelines rule, each separate criminal event should correspond to its own worksheet. So even though there's space for 3 offenses per worksheet, in this particular case, in my first criminal event, I have 2 offenses. So I only see 2 populating there. And then if I scroll, I see my second criminal event populating on the second worksheet, which is correct. And then there's still 1 overall guidelines range calculated between them, since these 2 cases are being sentenced together in front of the same judge on the same day. So that's a multiple criminal event, single sentencing event scenario. Are there any questions relating to MAGS, anything that I just reviewed before we conclude here?
Catherine,
Yes.
I just wanted to mention, there was a question concerning finding misdemeanor offenses. And you touched a bit on how to search for offenses. And I noted in the chat, but I just wanted to reiterate that there are some offenses with a maximum penalty of 1 year or less that are not included in our guidelines offense table because they do not get sentenced with any frequency in the circuit courts. But certainly, if you're looking for an offense and you don't find it in our offense table, we would encourage you to call us, because we, as offenses do start appearing in the circuit courts, we do add them to our offense table. So it's helpful if you clue us into those.
Yes, definitely. Thank you, Stacy.
Sure.
Okay, if there are no other MAGS questions, let me just pull up our contact information. Give me 1 second here. Okay, so just want to give you all our contact information. If you ever have questions, guidelines, or MAGS related, please always feel free to contact us. I'm always happy to help. Our phone number is 301-403-4165. Our general email account is msccsp@umd.edu. So we have 3 minutes. Does one last chance. Any outstanding questions before we conclude? Feel free to raise your hand, unmute yourself. No. Okay. All right. Well, thank you all very much for attending our session this afternoon. I hope you found it helpful and informative. And with that, have a great rest of your Friday and a wonderful weekend. Thanks all.